Swayam Prabha. Digital India. Educated India.
Welcome dear students. Today we discuss one of the important topic of corporate finance, that shares and share capital. I am Dr. Jaswant Saini, Associate Professor, Faculty of Law, MD, University Rohtak, present before you this topic, and this topic is very important due to some different aspects. Share and share capital, that aspect which is necessary to run a company, a corporate entity not survive without shares. And if there is no any shares, there is no any share capital, then it is impossible to work in the market. In this competitive era, when you not have the money in your hands, you not take some steps towards earning more money. So, shares and share capital play very important role in this direction. As usual, we start every discussion with learning outcomes. What we learn from this entire discussion. So, first of all, we learn about various types of shares and share capital. There are various type of shares and share capital. Both things are different. Shares and share capital, both things are different for conceptual study. Second one, to understand the shareholders' role in contributing to a company's capital. In company's capital, shareholders' role is very important, and without these shareholdings, the company not arrange the necessary money for the functioning of the company according to the object. Third one, to understand the features of equity shares and preferential shares. Basically, as a layman, we understand that two type of shares, one is equity shares, another is preferential shares, as a layman. But being a student of corporate law, being a student of corporate field, we know there are various types of shares and various types of share capital. So, in ordinary person or a layman generally presume that there are two type of shares, one is equity shares, another is preferential shares. And fourth one, to understand about the steps involved in issuing shares and understanding the purpose of offer document and its contents. Offer document we offer if that complete the process as laid down by SEBI. Offer document contents should be according to public policy, and offer document must satisfy the other condition which laid down by regulators, and SEBI is considered as the regulator of capital market and ultimate the control of central government on this entire market. Either that is a capital market or money market or any instrument relates to any market. They are ultimately under the control of central government. Central government, being a guardian of the public money, look after these issues which related to the market and which relates to financial transactions or the outcome of financial market rules and regulations. So, first of all, we try to understand here what is the meaning of shares. A share may be understood as an individual part or a singular unit into which the total share capital of a company is divided. It means, for example, a company incorporated with 1 crore shares of 10 rupees each. It means the share capital of that company is 10 crore rupees. Generally, in present scenario, nominal value of each share is 10 rupees. So, according to section 284 of the Companies Act 2013, that's define the meaning of share, and that's the very simple definition provided by statute of share. And you know it's very well, section 2 of each and every act generally after independence that relates to definition clauses. The purpose of here to define any meaning, to develop your understanding about this particular concept in very early stage. In very beginning, if you conceive the idea of meaning, that's very simple to develop understanding about the entire statute, about the entire act. So, section 2 define the definition by legislature. If anything already defined by legislature, that's very helpful in case of interpretation also and in case of other functions of the court also. If any matter already defined by legislature, then no need to be involved the judiciary in the futile exercise of interpretation. Interpretation only demand if meaning is ambiguous, if meaning leads to ambiguity, if meaning leads to absurdity. In such cases, the judiciary involve himself in this activity of interpretation. So, section 284 define the definition of share. Share means a share in the share capital of a company, and that includes stock also. So, there is no any other definition as this one. Share means share in share capital. It means how you participate in the share capital, that is the meaning of this one, and include the stock also. Shares and stock both are the interrelated terms, and stock is the wider term. Shares include in the meaning of stock also. Shares are used to raise the capital of company, and each share constitute a unit of ownership which is offered for sale. So, two important areas here I highlight here. Very first, if company wants to raise the money, they are free to issue the share. To issue the share or allotment of share is the one of the mode to raise the capital for the purpose of company. And second thing, once you hold the shares, you are deemed to be owner, and your ownership subject to fulfillment of other condition. But one thing is here, you are hold the ownership of this company. A share represents a part of the share capital. If you hold the share, it means you participate in the share capital of the company. And this is the important thing here. Once you decide to participate and you hold the shares, that's automatically prove that you become the owner of such company. No doubt, the property of the company, its own property, and that's not the property of shareholders. This property become the shareholders' property at the time of winding up. Otherwise, you sold this ownership right in the stock exchange anytime you convert this financial asset into cash. So, one of the example here, for example, this company is known as ABC Limited. ABC Limited has a share capital of rupees 50 lakhs divided into 5 lakh shares of rupees 10 each. Generally nowadays, the nominal value of each share is 10 rupees, and 5 lakh shares, it means share capital of this company is 50 lakh rupees. Mr. X is in possession of 6,000 shares, then he has a share of rupees 60,000 in the share capital of the company. So, this is the very, very important thing. How much you participate in share capital, that depends on holding, how much share you hold of the company, and that certified your rights of ownership, and other rights start with become the members in the company. If you buy the shares in primary market, you automatically become the member. If you buy the shares through the route of stock exchange, then you become the member after transfer of name. In your account, if these shares transfer, you become the owner, you become the member of the same. Meaning of share capital. A company is an artificial person, cannot generate its own capital, which has necessarily to be collected from several persons. These persons known as shareholders, and the amount contributed by them is called share capital. Shareholder you become with the own the shares and you participate in share capital. So, your ownership and holding relates to share capital you own by himself or herself through the route of primary market or secondary market. That's irrelevant. Material thing is here your name reflected in company member register. Once your name enter into company's member registered, you become the member, and rest of the rights are available to you being a member, and you become the member, first you become the shareholder. So, the number of shareholders are very large in public limited companies or MNCs or other companies whose setup is broad, who issue the various number of shares or whose share capital is in bigger way. The number of shareholders are very large. A separate capital account cannot be opened for each one of them. Hence, various capital contribution merge their identities in a common capital account, and this account is known as share capital account. If you participate through primary market, it means company itself issue the securities and company first issue the offer document. Against this offer document, if you apply to the company for buying the shares of such company, it means you participate in share capital, and every company who offer the shares itself, he need to be open a share capital account. The entire money of the applications should be transferred in this account. So, it is not possible to open the separate account for each client. So, to avoid this practical problem, they open one account. This account is known as share capital account, and this account is a necessary before allotment, and all the money should be transferred in this account, and that is a requirement also of a listing of the securities. No any stock exchange allowed to be listed the securities unless the entire money transfer in the share capital account. So, a company raises its capital by issuing shares to collect the finance and to carry out its business. Collect the finance and carry out its business. Basically, there are two reasons for whom company arrange the money. Collect the finance for what purpose? For the purpose of carry out its business. In the business scenario, without capital, without money, you not survive even a single second. Business is generally synonym of money. Where there is a business, it means the involvement of money is automatically applicable there. So, the memorandum of association that lays down the foundation of the company. Memorandum of association define for what purpose you collect the money, and that is treated as basic document or foundation of the company, and the amount of capital with which the company decide to register and the number of shares into which it is to be divided, that is defined in one of the clause of memorandum of association. Memorandum of association basically consists with 5 clauses, and all clauses are very important, and this document treated as constitution of the company, and one of them is capital clause. So, out of these 5 clause, only this capital clause you may alter with simple majority. Otherwise, rest of the clauses, if you want to alter, you need a special resolution for the same. So, this document treated as foundation of the company, that treated as constitution of the company. It constitutes the basis of capital structure, how many share capital, division of the share and share capital, these all things defined in Memorandum of Association capital clause, and that's basis of capital structure of a company. When total capital of a company is divided into shares, then it is called share capital. It means share and share capital, both terms are interrelated with each other, and there is no any chance to be presumed single one unit. If there is a share, share capital automatically there. If there is a share capital, that's automatically relates with the shares. So, they are the interrelated terms and there is no any meaning of a single unit. So, categories of share capital, basically lot of types, or you may say various categories here defined in the statute book of share capital. We start with the authorized share capital, that's defined in section 2 subclause 8 of the Companies Act 2013, and this authorized capital as the amount of capital that the memorandum of the company authorize as the share capital of the company. So, where you found this memorandum of association, and authorized by whom? Generally every authorization here in case of companies by member, those who are the shareholder of the company, if their names enter in the company's member registered, they are member and they decide each and everything in the meeting. Either that's a annual general meeting, either that's a extraordinary general meeting. So, every type of authorization here given by the member. Members are the ultimate owner of the entire property of the company. Being a owner, they decide the policies of the company, in which direction companies start working, and two components here which decide the functioning of company. Very first, memorandum of association which we draft at the time of incorporation of the company. Second one, the members meeting where we decide the policies. Members are free to decide the policies of company being a owner, and memorandum of association that certified that you first incorporated with these clauses, with these objects. Nowadays or at present you are not allowed to shrink from this object. So, authorized capital is the amount of share capital which company is authorized to issue by its memorandum of association. So, each and everything must be authorized by some documentary proof. So, in case of capital, the documentary proof in our hands, that's memorandum of association, who define what amount of capital is treated as authorized share capital. The company cannot raise more than this authorization. It means the restriction is here applicable. The amount of share capital authorized by section 2(8) of the Companies Act, and if company going beyond this limit, this act is known as ultra vires act, and this clause defined in memorandum of association of the company. It is called as registered capital. You may be say authorized capital, you may be say registered capital, both are same, both are synonym of each other. The authorized capital can be increased or decreased. So, that is the important point here. You if wants to increase or if you wants to decrease, the both type of activities in your hand. That is the discretion of the members. They may increase or decrease as per the demand of business, as per the demand of circumstances. But procedure laid down in the Companies Act, you must follow this procedure. Memorandum of association you need to be altered according to the demand of members. But Companies Act impose some conditions or riders to exercise this power. You must follow the same. The company need not issue the entire authorized capital for public subscription at a single time. That's depending upon its requirement. As and when you required, you may be issue any part of the authorized capital. Once you authorize, you may be raise the money through this authorized capital in one instance, or you may be in various installments, you may increase the capital. So, it may issue share capital, but in any case it should not be more than the amount of authorized capital. In any condition, you not cross this limit of authorized capital. Any time may be increase, may be decrease, but the limitation is here applicable. It means as decided by memorandum of association. So, issued capital and subscribed capital, they are the other types of capital. Issued capital defined in section 2 subclause 50 of the Companies Act 2013. It means such capital as the company issues from time to time for subscription. And subscription basically means when you offer the document, respond by investors, and on the basis of these terms and condition, if someone ready to buy these shares, those known as subscriber, and they submit the amount that's known as subscription amount. So, it is that part of the authorized capital which is actually issued. It means authorized capital is different and issued capital may be different, may be same. That's depend on the discretion of the board of directors. Public for subscription including the shares allotted to vendors and the signatories to the company's memorandum. So, that's depend on the discretion of the company. Either they issue the entire authorized capital in one instance, that's known as issued capital. If against this issued capital you find out the application money against the entire capital, that's known as subscribe. It means how many persons are agreed to buy the shares against your offer document. That's defined here, that's decide how much issued capital, how much authorized capital. The authorized capital which is not offered for public subscription is known as unissued capital. So, that part of the capital which not offered to the public for subscription, that is known as unissued capital. This unissued capital may be issued anytime by the company on the basis of the decision taken by board of directors or in members meeting, that's maybe AGM or maybe EOGM. So, subscribed capital defined in section 286 of the Companies Act 2013. Subscribed capital means such part of the capital which is for the time being subscribed by the members of a company. So, authorized capital is entire capital which mentioned in the memorandum of association. Out of these, how many you issue, that's known as issued capital. Against this issued capital, how many applications you receive, that's known as subscribed capital. So, they are interrelated with each other and they are the complement and supplement for each other. So, if members subscribe for the same, if investors ready to subscribe for the same, that capital is known as subscribed capital. So, it is that part of the issued capital which has been actually subscribed by the public. It means if the intention of the investors public is clear regarding buying this part of capital, that known as subscribed capital. When the shares offered for public subscription are subscribed fully by the public, the issued capital and subscribed capital would be the same. It means if your issue fully subscribed, then both are same. Issued capital and subscribed capital become the same. It means the amount of the both capitals become same and they are become one. But if you not receive the application for entire issued capital, then issued capital and subscribed capital may be different. So, the logic is here, if you apply for 5 lakh shares, it means you offer to public for 5 lakh shares and you receive the application for 5 lakh shares, in such cases both capitals become same. The subscribed capital may be equal or less than the issued capital, that based on subscription offer by members, subscription offer by prospective investors. Either the capital is same or different, that based on subscription offer by public. So, called up capital and uncalled capital, we try to understand these concepts also. Called up capital defined in section 215. According to this section of Companies Act 2013, it is that part of the subscribed capital which has been called up on the shares, meaning by that what the company has asked to the shareholders to pay. If company is not interested to take the entire amount of this subscribed capital, if company agree to accept the partial amount, so the capital may be called up different and subscribed different. So, that is depend on the nature of capital, which type of capital they accept, or what is the meaning of such capital, that is reflected on the basis of their subscription part or decision taken by the members. The company may decide to call the entire amount or part. If company call the entire amount, then both capitals are same. If company accept the part of the face value of the shares, that is the meaning of both are different. Nominal value of each share is 10 rupees. If you demand 10 rupees and receive 10 rupees, then both capitals are same. If nominal value of out of this 10 you accept only 2 rupees and 8 rupees remaining, this remaining amount you may be called any time, and this is known as uncalled capital. This capital known as uncalled capital, you may be called any time. So, for example, here the face value also called nominal value of the shares, and generally that is the 10 rupees against each share, and the company has called up only rupees 7. If company only decide to call out of this 10 7 rupees, in that scenario the called up capital is rupees 7 per share. The remaining rupees 3 may be collected from the shareholders as and when needed, as and when company demand. When company demand this amount, members are bound to be pay this amount, and if you not pay this amount at the time of call, your shares may be forfeited on this account of non-deposit the amount on call. So, uncalled capital, it means that portion of the subscribed capital which has not yet been called up by the company. If company call up the entire amount, then you are no liability of the members. The company may collect this amount at any time when it needs for further funds. So, 3 circumstances here. These circumstances prove that this amount you may be deposit at the time of call. That is the mandatory obligation on the part of members. If you fail to pay this amount at the time of call, that has become the ground of forfeit your shares. So, company may call any time when company found the adequate surplus are not available to the company. They may be called this uncalled share capital. So, paid up capital and reserve capital, that is another area which we need to be discussed here. Paid up capital is that portion of the called up capital which has been actually received from the shareholders. actually received. Called up capital means company call this much amount, but against this call how many persons pay, that is known as paid up capital. When the shareholders have paid all the called amount, the called up capital is the same as to paid up capital. So, called up capital and paid up capital both are same if both satisfy the requirement. It means called up capital is equivalent to paid up capital if entire shareholders agree to subscribe the same, agree to pay the same. So, second important thing in this direction, you try to understand, if any of the shareholder has not paid amount on calls, such an amount may be called as calls in arrear. If you pay, the amount becomes same, called up capital and paid up capital. If there is a difference, those defaulters' money, that is known as calls in arrears. It means those members who need to be paid this amount and they fail to pay this amount, that amounts to calls in arrears, and therefore paid up capital is equal to the subscribed capital. And the another important concept is here reserve capital. A company may reserve a portion of its uncalled capital to be called only in the event of winding up of the company. If you reserve this capital for some specific purpose, this capital is known as reserve capital. Such uncalled amount is called reserve capital of the company. Why that is called reserve capital? Because you may be called any time as per statute, and members are bound to pay this amount of money as and when company call this amount. So, that is like to obligation on the part of members. It is available only for the creditors on winding up of the company. If you not call this amount during the lifetime of company, and if you call this amount at the time of winding up, it means this is for the benefit of creditors. The creditors claim first satisfy from these free reserves if other reserves are not available on the part of company. So, now we try to understand what is the nature of shares, and this nature of shares basically reflected in section 44 of the Companies Act 2013, who define company shares are movable property. Shares refer to the unit into which the total share capital of company is divided, and every share is known with distinctive number. Distinctive identity number should be reflected with each share. A share is a fractional part of the share capital. So, that is the part, and which type of part? Fractional part of the share capital, and forms the basis of ownership interest in a company. If you hold 10% of shares in a company, it means you hold the 10% ownership of that company. So, ownership and holding basically in proportionate of the same, and that is fractional part prove that you are the owner of the company. The persons who contribute money through shares are called shareholders. If you participate through this share capital, you are considered as shareholders because you participate in share capital. So, you become the shareholders. Once you become the shareholder, it means you become the owner. Once your name enter into the company's member record, company member registered, the rest of the rights available to you. You participate in company decision, you contest the election of director. So, you participate through this ownership in each and every matter. The amount of authorized capital together with the number of shares in which it is divided is stated in the memorandum of association. So, I already explained before you, this clause, capital clause reflected in memorandum of association, and this document is treated as constitution of the company. and how many classes of the shares, that is also reflected here, in which the company's capital is to be divided along with their respective rights and obligations are prescribed in Article of Association. Article of Association basically define the process, how you acquire these shares, and the classification defined in Memorandum of Association, division of this share capital defined in Memorandum of Association, but procedure defined in Article of Association. As per the Companies Act, a company can issue two types of shares. I already in the opening words of this lecture, I clear basic idea in the minds of laymen. There are two types of share, one is preferential share, other is known as equity shares. And otherwise, being a student of businesses, being a student of law, we know that there are various types of shares, not only two types of share. So, one by one we try to touch here every type of shares. According to section 43 of the Companies Act 2013, two type of shares, one is equity and preference, and that's differentiation is given here. An equity share is a share which is not a preferential share. So, that's a very simple definition here reflected in this section 43. If a share is not a preferential share, that's automatically treated deems to be a equity shares. In other words, share which do not enjoy any preferential right, and you know it's very well, preferential rights are available at two times, and these rights in the payment of dividend, at the time of dividend or repayment of capital. They are the two places, two times. If someone enjoy the preference right, someone enjoy the preferential position, that's known as preferential shares. If these two times preference is not given to any shareholder, they are known as equity shareholder. So, equity shareholders are entitled to share. Equity shareholders are entitled to share the distributable profits of the company after distributing the dividends to the preferential shareholder. So, first right goes to preferential shareholder. After that, if any dividend remain, that will be distributed among the equity shareholders. The dividend on equity share is not a fixed, and it may vary from year to year, depending on amount of profit available for distribution. So, generally preferential shareholder may claim with the fixed rate of dividend, and they are not allowed to be participate beyond this limit of fixed amount of dividend. But there is no any limit on the participation in dividend on the part of equity shareholders. The question is here, why there is no limit? Because they are the owner of the company's property, and there is no any limit on ownership rights. And equity shares capital may be with voting right or without voting right. So, DVR is the one of the new concept here, which relates to voting rights may be different from dividend right. So, equity share capital may be with voting right or without the same. Differential voting rights, dividend or otherwise in accordance with such rules and subject to such condition as may be prescribed in the Article of Association of the company or in the offer document. Later on, I explain before you one of the example where we discuss the DVR, differential voting right. And in our India, only 4 companies issue these DVRs, and after that this concept may be withdrawn by the central government. Example of DVR here you found in 2008, the renowned brand Tata Motors issued 6.4 crore shares with DVR. DVR here refer to differential voting right, and they issue against the value of 305 rupees to raise the funds. The main objective of issuing such type of shares, means DVR, the enough funds to acquire Jaguar Land Rover. This Tata Motors wants to acquire this famous company of four-wheelers, Jaguar Land Rover. The said DVR extended 1/10 voting right of the company's ordinary share and offer 5% more dividend to the investors. Voting right is your 1/10 in comparison of other shares, but your dividend right more than 5% in comparison of other shares. So, these type of shares known as DVR. DVR means differential voting right. Only till now 4 companies of the India issue these DVRs. Importance of equity shares. Importance for whom? Importance for 2 institutions. One institution is known as company and another institution known as shareholder. The company is not liable to pay dividend in case of loss or insufficient profit. So, the question is here, if company not earn the profit or company fail to secure the sufficient profit, in such cases you not claim dividend as a matter of right. Your right of dividend reflected with this one, once company earn the profit, second one company declare the profit. If company earn the profit but not declare the profit, in such cases you not claim this dividend. So, if company not earn the profit or not a sufficient profit, the company never declare the dividend. The company uses the equity shares capital for a long period, as this capital has to refund it at the time of liquidation only. So, the equity shareholders' money never returned by the company. Company only return the money if that relates to preferential shares, if that relates to debentures or loan or credit or borrowings. So, in the lifetime company generally not return the money of the equity shareholders, and this is for the purpose of company. For the purpose of shareholders, the equity shareholders have the voting right to elect the board of directors. In case of company, we exercise each and every right in the meetings, either the meeting of board of directors, either the meeting of shareholders. They can control the management of the company through this way. You elect the directors, you remove the directors, and when you exercise this power, then you exercise the managerial part. You participate in management through your voting. All the profit after satisfying debenture holders and preferential shareholders belong to equity shareholders. Therefore, they are likely to earn more return when the company is earning more profit. So, if more profit, there may be chance to earn more dividend. So, now we are coming here in this part, how many types of preferential share. Basically, there are various types. One is cumulative preferential shares, another is non-cumulative preferential shares, redeemable, irredeemable, participating and non-participating preferential shares. And we know these 6 types we discuss in detail in our next discussion here. Preferential shares, according to section 43 of the Companies Act, a preference share is one which fulfills the following condition. What those condition? Preferential right if given to those shares, that's known as preferential shares. And preferential right of whom? Preferential right of one, dividend, and second, at the time of participation in the assets at the time of winding up. So, paid that it carries a preferential right to dividend to be paid either as a fixed amount will be paid to the preferential shares, or amount calculated by a fixed rate of the nominal value of each shares before any dividend is paid to the equity shareholders. That with respect to capital, it carries or will carry on the winding up of the company the preferential right for repayment. So, one is here dividend, second is participation in the repayment scheme. If at 2 times you exercise your preference, you are entitled to participate as a preferential party. That means you hold the preference shares. So, classes of preferential shares here we already discussed in chart, but that's we discuss here in detail. Cumulative preferential shares, when unpaid dividend on preferential shares are treated as arrear. It means if company not earn the profit in any financial year, that your right to claim dividend being a preferential shareholder carry out or carry on next year, it means that's cumulative preferential shares. It means you claim double in the next year, in subsequent year, such preference shares are known as cumulative preferential shares. If you are not allowed to be claimed dividend in next year, it means those preferential shares are known as non-cumulative preferential shares. Non-cumulative means your right lapse, your rights comes to be an end. It means your right forfeited here. Any financial year, company not earn the profit, it means your rights to claim the profit comes to be an end. So, these type of preferential shares known as non-cumulative preferential shares. If no dividend is paid in particular year, it cannot be carried forward for next year. So, that is a very simple difference here for cumulative and non-cumulative preferential shares. Now, we try to understand here with the redeemable preferential shares and irredeemable preferential shares. Those preferential shares which can be redeemed or repaid after the expiry of fixed period or after giving the prescribed notice as desired by the company are known as redeemable preferential shares. It means on the date of maturity which determine at the time of offer document, at the time of allotment, those shares known as redeemable preferential shares, and terms and condition of redemptions are announced at the time of issue of such shares. Generally, these conditions are mentioned in the offer document. If that's not clearly mentioned, then you refer these condition, you highlight this condition at the time of allotment. So, 2 options are available to you, and another type of preferential shares are known as irredeemable preferential shares. Those preferential shares which cannot be redeemed during the lifetime of the company. So, this word indicates that they are known as irredeemable preferential shares. If you want to encash this instrument, then you sold this instrument in the stock exchange. It means you follow the route of stock exchange for buying and selling in these instrument, but company not take back this instrument in the lifetime for payment purpose. The amount of such share is paid only at the time of liquidation of the company, and this is the very important difference here. Now, another type of preferential shares are participating preferential shares and non-participating preferential shares. Participating preferential shares are those whose right survive to participate in surplus profit. In surplus profit, if you are allowed to be participate after paying the equity shareholders in addition to the fixed rate of their dividend, they are called the participating preferential shares. Holder of share, such shares get return on their capital in 2 forms, one fixed rate, second in surplus profit. And another type of shares are non-participating preferential shares. As per the name, they are not allowed to be participate in excess profit. The earlier they are allowed, but in this case if they are not allowed, they are known as non-participating preferential shares. Convertible preferential shares and non-convertible preferential shares. So, as per the name, which can be converted into equity shares at the option of the holders after a fixed period according to the terms and condition of issue, are known as convertible preferential shares. And non-convertible preferential shares which are not converted into the shares, they are known as non-convertible preferential shares. And there are some grounds of difference between equity share and preferential shares. On the basis of rate of dividend, we differentiate. Preferential shares are paid on the basis of fixed rate and equity shares are vary. On the basis of arrear, we also differentiate here. Cumulative preferential shares and equity shares can't get the arrear of past. And on the basis of dividend, equity share receive dividend later, preferential share claim dividend first. And participation, equity shares participate in management, preferential shareholders are not allowed to participate in management. On the basis of redemption, they preferential shares redeem as per terms and equity shares not redeem except scheme introduced by the central government. If central government introduce the scheme, then the purpose is different, then position is different, otherwise not applicable. So, there are some areas we discussed: distinction between equity share and preferential share on the basis of rate of dividend, on the basis of arrear of dividend, on the basis of redemption policy, on the basis of participation in management, on the basis of dividend paid, issue of shares. Some salient features of the capital of companies that amount on its share can be gradually collected in easy installment spread over a period of depending upon its growing financial requirement. And if the entire amount paid on one installment, it means you pay the entire amount along with your application. So, a company may be called this amount in installments or maybe in one instance. That's depend on the policy of the company. And important steps in the procedure of issuing a shares: first you issue the prospectus. That's the obligation on the part of company issue the prospectus to the public, and this prospectus is an invitation to the public that a new company has come into existence and needs fund for doing business. If you are the interested, you may be provide these funds to the company if other conditions satisfy, if the offer document suit to you. This offer document prospectus contain the complete information about the company's working, and if these conditions suit to you, you may be apply your hard savings in this company. And after that, issue the offer document, they receive the application, and as per SEBI guideline, unless and until company receive the 90% subscription against this IPO, no any company allowed to allot the shares. In case of minimum subscription requirement is not met, the application money should be refunded within 15 days. And this undertaking, if given by someone, those known as underwriters, and they charge the underwriting commission for the same. So, that is the requirement of business. Nowadays, you appoint first underwriters. Then after that, allotment of shares. Allotment of shares depend on subscription. It means if minimum subscription has been received, the company may proceed for the allotment, and letter of allotments are sent to those whom the shares have been allotted, and money is refunded to those whom to allotment has been not made. When allotment is made, it results in a valid contract between the company and the applicant. If once a allotment made, that's applicable as an agreement between the company and the particular person. So, private placement of shares, that's deal by section 42. Private placement means offer of securities or invitation to the particular group of persons. If you only offer to a selected group of persons, that's known as private placement. And ESOP, employee stock option plan, is also here. A company may offer to its employees and directors to subscribe for the company at lower than its market value or fair value at a future date. So, this option is known as ESOP. It began an option granted by the company to their employees and directors. So, now we are here on summarize part. We summarize the entire discussion in these 4 bullets. Very first here, shares and share capital play a important role in capital formation of the company and providing the necessary funds to initiate and expand business operation of the company. Share represents the units of ownership in a company. Share capital is collected from shareholders and is the foundation of company's financial structure. Sufficient share capital provides financial flexibility to the company. If a company has sufficient capital, then there is no any other way unless and until company other policies suitable, they earn the profit and profit. So, to raise the funds without incurring debt, that is the very cheapest mode to collect the funds. The issuance of shares through the capital market fosters investor confidence. Once a company subscribe fully or oversubscribe, it means that's establish the confidence of the investors in the market. Once a investor's confidence establish with your company, then there may be a higher chance to grow in the market. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.